for your time today. And looking at the long weekend, I really appreciate your time today and your interest on the subject. I assure you today's topic will give you add-on the knowledge with the expert panel we have. The kind of discussion is going to take place. You will have something very interesting to learn from this today's topic. On the panel today, of course, we first invite and say thank to Mr. Bala, our own Mr. Bala. And I will not now introduce, like me, is well known only with our all, it's connected with this webinar always. Today's our two panelists of that, Mr. Shailesh Dholakia is a qualified company secretary and has completed LLB from Mumbai University. Has 24 years experience in secretarial and legal work under various corporate laws, SEBI regulation, listing, Fema regulation, and preferential issue of share, QIP, buyback, merger, acquisition. He is currently Vice President Corporate Secretarial at Reliance Industries Limited and was previously working with All Cargo Logistics and Z Entertainment Enterprise Limited as a Company Secretary and Compliance Officer. Welcome, Shailesh Bhai.
Thank you very much.
Our another panelist, our own Mr. Vishal Mehta. I say our own because he is ex-Mehta, proud moment for me and I hope for him also. Vishal Mehta has completed graduation from Mumbai University and law from also Mumbai University. He is qualified company secretary and he was admitted to Bar Council of Maharashtra and Goa for the year 2009. He is at present, before joining Vertices Partner, Vishal was working as a legal manager with ICICI Prudential Life Insurance Company Limited as an associate partner with Mehta Mehta. He is a corporate commercial lawyer and has been involved in advising foreign and Indian corporates, entrepreneurs, startups, social business enterprise, and other organizations on a range of legal and statutory regulatory issues. He has been involved in formation of alternative investment fund, corporate governance, corporate secretarial advisory. He's been advising clients across diverse sectors, including NBFC, Fintech, EdTech, HealthTech, insurance, banking sector, e-commerce, and pharmaceutical. Thanks, Vishal.
Thank you, ma'am. And I'm happy to have been invited by Mehta and Mehta. It's indeed a proud moment for me to reassociate with Mehta and Mehta. So thank you, ma'am, for the brief introduction. And I'm happy to share my thoughts on the topic of foreign direct investment, which is a burst thing from the liberalization state, which is there. So happy to share my thoughts on it. Thank you.
So welcome, friends. FDI. Now earlier, few years back, FDI was exception. Now it's a common. Every third company will have FDI. Earlier it was big company. Now even forget about medium companies. Small company have FDI. So it's like a kind of secretarial practice. Only becomes FDI compliance has become a practice, part and parcel of CS practice, and in the area of employee CS as well. So I thought in addition to company law, we should take this foreign direct investment as also our knowledge sharing session topic. And in that, again, not only compliance, we are going little ahead and we are telling that where FDI is allowed, which format, and what are the problems actually in inviting the FDI, so that you can help your company, your client, to understand and solve the situation and give some guidance to your own corporates and the clients as well. With this, I'll not take much time. I'll invite Mr. Bala to introduce topic for 2 minutes, and then both the panelists can say a few words on the topic of their view, and then we'll start the presentation. Over to Mr. Bala.
Good morning to all of you. I have a great pleasure in welcoming you all for today's session, and on my own behalf and as well as on behalf of Mehta. When we talk about the FDI, we all know what is happening from the TV news and also newspaper channels, etc. And also see every alternate day there has been news. You might already watched Swiggy, one of the largest food industries, actually making an investment. You might also watch Google has actually invested in a Bharati Airtel in India. And then similarly from Canada also, there are some of the pension funds who acted as a anchor investment. They have invested in various Indian companies. And very recently, there was a news item which was there announced by the ministry stating that the Indian green energy has also received the foreign investment. And not only that, more and more government is also making a lot of relaxation on the foreign direct investment in the various sectors like defense sector and the PSU, oil, telecom, and private, and again power sector. So all these things are all showing definitely the importance of the FDI. FDI definitely is going to contribute to the economical growth of the country. And the very latest news, you might also seen that the LIC is actually going for a public issue. And in fact, they are putting up the proposal that the 20% FDI should be permitted to the LIC, which is actually on the way. In the current year budget also, they are all talking something on the space sector. Indian space sector, they are planning to introduce a new bill that will actually outline what are the various foreign investment which will actually take up in the space sector. And similarly, telecom, you are all aware, it has already been increased from 49% to 100% FDI in the automatic mode. Similarly, insurance sector is also increased to 74%. These are all actually shows what is the importance of the FDI. And second thing is there, as our panelists said very clearly, there are certain sectors where FDI totally not allowed to prohibit it. We will look into that when the presentation takes place. And again, FDI, whether it is a lengthy procedure or it's a easy procedure, etc., all this thing, automatically there are two routes are available. There are something called the automatic route where you don't need to get the approval. Things are actually permitted with the RBI regulating it, etc., and all this thing, reporting requirement. There is another way where this is not falling under the automatic route. You need to make an application, take the concerned approval from the ministry subject to sectoral gap, etc., and other things. Basically, this presentation is going to aim at these aspects. And since we have the two eminent panelists who are already there with us, they will be sharing their practical experience on the FDI, and we will get to know more practical aspects of insight. It is going to be the day of the order in future for any company to grow, because it is definitely going to not only help the companies to grow, but also going to contribute towards the nation's economical growth. With these few words, I will request any of the panelists, they could add some few words before we start the presentation. Over to Vishal.
Thank you, Bala sir. So as Bala sir has given a brief introduction about the thing about how FDI, the recent liberalization which has occurred, and the in various sectors which has been open for the foreign investment, which is a key to it. Along with it, what it means, the LPG movement which we started, that is a liberalization, privatization, and globalization movement which started. There were three phases which we divide into it. The phase one, which starts from 1973 to 1991. 1991 phase, where the liberalization, where the industry gets open up for the foreign investment from 1991 to 2000, and the phase which we are in, which is the 2000 phase till now, which is there. Of late, which we see the way the proactiveness which has been shown by the government and the openness which is there, which is for the foreign direct investment, because it's a win-win situation when it is there. It is for not only for the foreign investors, it provides an avenue for investment. For country like developing country like India, it provides a economic boost for it. It provides a visibility in the global stage where we are today, where we see the products which is there, the Make in India initiative which was being formed, the Atmanirbhar Bharat program which has been formed, the Startup India part, because lot of deals which we do in the startup segment also, there is interest, immense interest by foreign investors across industry broad sector which is there, whether it's an approval route or automatic route which is there. And when we see a foreign investment, if you see the statistics, what it says that out of the foreign investment, 98% comes through automatic route, and almost all the sectors are open in the market which is there. So 98% segment covers the automatic route part of it. And the interesting thing which was being done, if we see the last year, we recorded the highest FDI in India, which has been recorded as part of it. In spite of there was a restriction under Press Note 3/2020, which came into effect that an investment through a land border can't be made in India except without a prior approval, which is that still India witnessed the highest FDI in the last year part of it, which is that. So you can imagine if that restriction would have not been that, then it would have been way higher, but that restrictions was required because of the COVID-19 pandemic situation which was there. It was a very fragile stage whereby it was possible that there may be a takeover opportunity or acquisition opportunity to take over the Indian assets which is there. So that is open up in a significant way part of it. Still there was a response which has been given by foreign investors across globe. It is a tremendous response which is there from point of view, and there is a liberalization not only from a investment sectorial limit, even from a process point of view. There is a single window clearance system has been implemented, which is the process to take approval from a foreign investment point of it. So that's are the core structural reforms which has taken place, which has given and which has placed India. Today, India ranks in one of the 9th position of receive of foreign investment across globe, which is there. And no doubt, going forward, we can reach to top 5 of the country to receive the foreign investment because of the geopolitical pressure which is there, or the geopolitical situation which is aligned in India across the globe, which will give India an opportunity to scale up in part of it, which so that is an extraordinary situation which we are living into, an era of entrepreneurship. When you see each day we are producing unicorns, it is date 93 unicorns which has been reproduced by India, which is there. So that is the which is taking place, and we will discuss various nuances of FDI. There are interesting case of Future and Amazon, which is a daily headline in newspaper. If you see, that is also one of the case law which will be discussing it. The nuances of what is capital, what and how to structure it, because at time when a foreign investor comes, the structuring becomes more important point of view, that what is the way whereby you give a comfort to an investor also, and simultaneously you protect the interest of the founder or the promoter of also of Indian company. So that are the nuances which we will be discussing in today's presentation.
Thank you. Thanks a lot, Vishal. Over to Shailesh bhai on your few words on your topic. You are on mute, Shailesh. You are on mute.
Oh, sorry, I didn't realize. So, good morning, everyone, and thank you very much for giving me this opportunity to be a panelist for this very good topic, what we have selected on foreign direct investment. And as Vishal said, is absolutely true. We are looking at multiple levels, the investments coming from the foreign investors in India, especially when our government is talking about the 3 trillion economy. How this is possible? This is without this FDI is not possible. And we have seen from 1992 onwards, where the liberalizations doors were opened in the Congress government, and a lot of foreign direct investments start flowing in. So since 1992 till date, a lot of reforms have been introduced by various governments. And earlier there were a lot of restrictions with respect to the foreign direct investments, but now it has been made with ease of doing business in India. A lot of relaxations have been given by government to facilitate the foreign direct investment in India in various sectors. So very few sectors are now left where foreign direct investment is not permitted. But I hope with the going economy and seeing the necessity of foreign direct investment in those sectors also, the government will soon announce some good measures also to have the foreign direct investment in these sectors as well. But nevertheless, this topic has been very close to me because I have worked very extensively on foreign direct investment proposals in past, and I'll definitely at times I will share my feedback also and my personal experience also, and for the viewers of this program. And I'm happy to be sharing my experience and sharing my views also on these topics. So over to you, Vishal. We can continue.
I think now, thanks, Shailesh bhai, we can start the presentation. So, Prashant, you can start the presentation.
Good morning, everyone. Today I'm going to talk about FDI, which is very sensitive and very important topic, as anything which relates to money is really crucial. And we'll discuss how foreign investors and foreign residents or corporates can invest in India, an Indian company. So, what is investment? Investment is something that domestic companies and assets of other country by Indian investors. FDI is an investment by a person outside India on repatriable basis in equity of Indian company or LLP. It is a major source of non-debt in financial source for economic development. FDI can be defined as investment through equity instruments by resident outside India in Indian unlisted companies or 10% of the paid up capital of fully diluted listed company. There are always advantages and disadvantages of everything. Here are some advantages like economic growth, human capital development, improved capital flow, increase in export, ease of international trade. And there are some disadvantages like domestic investment is hidden here, risk of for political changes, economic non-viability, higher cost, modern day economic colonization. Government has actually taken very much initiatives to boost FDI in India. It's like investment clearance cells, national single window, product PLI schemes, which is helps making India one district, one product. RBI permissions are not required for establishment of branch offices, license offices, and project offices for sectors like defense, telecom, and more of them. Local source norms relax up to 3 years for entities undertaking single brand trading of products of age cutting and technologies.
Prashant, just go to slide. We can just speak about the PLI scheme also.
Yeah.
So the production link scheme, that's a scheme which was being launched during the COVID pandemic, is a big part of it, which is there to attract investment in India. Now, the reason of it is to make India as a manufacturing hub. The reason is that to make to place, because right now, if you see, you take any product, every second product you will find as a make in China. What we want is make in India product to be part of it, to attract investors, to see, to have a global visibility of Indian products, which is there, because yes, we can scale up, we can do it. It is there to increase that. That's a reason of PLMI scheme. PLI scheme is available for 14 sectors, which is there. The prominent sectors where it has been available, it's auto part of it, pharmaceutical, food processing, and there is a lot of interest which has been shown across globe. It is almost around 60,000 crore interest in the PMLI scheme is being shown. And what exactly PMLI means? PMLI means it's an incentive based. Once the investment is being done, the investment, once the production reaches a threshold, and the threshold will give, the government will incentivize up to 4% or 6% against the revenue which gets generated. That's the cream, that's the flavor which has been introduced, and that's the response which government has received from across the globe. Across all manufacturing. It's a global, it will place India as a global manufacturing hub and a global supply chain part of it, which will open up not only the manufacturing sector, but other integrated sector related to manufacturing also. That's the impact which will have the Make in India or Atmanirbhar Bharat program, which has been launched. And again, the one district, one product is to focus on a specific product of the one district which is there. It is to invite a rural entrepreneurship. It is to spread the product, to spread one specific product of one district. And it's just been implemented in phase 1 and phase 2 product stages. Phase 1, already 137 products has been launched. Phase 2, 736 products are to be launched. And there is an immense investment in tier 2 and tier 3, because till now what we have seen up to 2012, it was always tier 1 and metro cities which were focused for the investment which is there. But what has expanded is the tier 2 and tier 3 where the investment is being attracted. So it's not the foreign investors is looking beyond tier 1. It's looking to for a rural entrepreneurship to promote. That's a promotion of an entrepreneurship, promotion of an investment at the root level, from where the impact will be visible, and it will place India in a place where it can compete with China also.
Thanks, Vishal. And I think PLI is having a very big impact, and more industries asking to include them in PLI so that they can be promoted, I think.
Right.
Which means today what we are talking about, Darjeeling tea, which is, I can give you a very popular example of one district one product. It is such a popular thing.
Yeah.
The same way we want to popularize the product, which will actually get the things
Each
and
and
get the
every district,
yeah, that's it.
Yeah, thank you. I think Lotman is there, otherwise we can talk, I know, lot, but I think Prashant, we proceed.
Sure.
Yeah.
Because it's very end-to topic, this, for our country investment.
There are two major parties in FDI, investor and investee. So the eligible investors are non-resident entity, non-resident Indian OCBs, foreign institutional investors, foreign portfolio investors, NRI residents in Nepal and Bhutan, companies, trust, partnership firms, and FVCI. So the eligible investees in which investors can invest are Indian companies, LLPs, partnership firms, trust, investment.
Prashant, 1 minute, go to earlier slide and give full form of FVCI, no?
Foreign venture capital investors.
Right. Please use when, because many may not. Next, thanks.
The investees in whom investors can invest are Indian companies, LLPs, partnership firms, trust, investment vehicles, and startup companies. Investment by NRI in partnership firm and proprietary concerns can be through only non-repatriable basis, provided that the investment is done by inward remittance or out of the NRE FCRN account maintained by authorized dealer and authorized banks, and it is not engaged in agriculture, plantation, or real estate business. Prior permission of RBI is required and no consultation with Government of India is required. There are only two routes, automatic and government. Under automatic, no permission is required for investment, but in approval route, an application for approval has to be submitted to FIFP, which is
Facilitation. That's a foreign, that's a foreign investment facilitation portal. Is there now under automatic route and government route? What's the distinguish which is there? As majority of industry, as Professor Bala highlighted, that majority of industries are under automatic route. There are few of them which are still under government route, which is required. And why it is required? Because of the sensitivity of a sector which they are into it. The national security requires that to be there. Its government should be aware about it. What are the modalities under which it comes into three, whether it's a data localization part of it, because data is the next oil. Data is where the things are getting played off. So that is the requirement which is there, where the government route kicks in and where the requirement is there. It's a defense sector, MBRT, which we will be covering in the next slides which are there, what comes under government route, but why it is government route, that's also crucial, and why it will still stay in government route because of the sensitivity of the sectors.
That is absolutely right. Because of that, there is a Department of Industrial Policy and Promotion Board, which is actually the DIPP. So that Department of Industrial Policy is actually outlines what are the various restrictions, what are the various subject to approval, etc., which is to be done. So from that point of view, the application has to be made, it has to be done, although it is under FIPP, but the application and other thing has to go to Industrial Policy and Promotion Board. Yeah. Go ahead, Prashant.
There are also some cases in which fresh approval is not required. When, for example, if a company was under approval route and then it is converted to automatic route, then no approval is required. And the additional foreign investment up to cumulative of 5,000 crore into same entity, which within an approval for an equity percentage or into a wholly owned subsidiary. The regulators, the rules and regulation applicable for foreign direct investment are Fema, NDI rules, consolidated FDI policy, and RBI regulations. Recently, Press Note 3 was given by government, which requires prior approval.
Just hold on. We'll just give.
Yes, sir.
Prashant, can we just go to the previous slide once?
Yes, sir.
Okay, see, these are the core rules and regulations which are there. Just to give a brief glimpse about it, what exactly it is part of it. Earlier, it was a TISPRO regulation that 2008 regulation which was there, which governs the part of now. In 2019, it divided the current account and capital account transactions get divided into earlier the domain, the nodal agency was RBI. Now the capital account transactions move to central government, whereby in 2019 the regulation of non-GAAP regulation came into play, which is governed by central government. The debt regulations are governed by RBI part of it. So there is a split of activity which has been done at central government and at RBI level, which is there, which prescribe basically, and there was a consolidation of various regulations also which has taken place when a debt and non-debt regulation came into play. Foreign investment policy, earlier the norm was it was through press note and press releases which was been done. In 2000, a system started of a consolidated policy. That's a yearly review of the existing policy, existing press note and amendment which comes into play. From 2000 on yearly basis, there is a consolidated FDI policy which gets released every year, part of it, and which consolidate all the press note or gives any clarification which is required in specific sector part of it. So that is the way when we read, when a regulation has to be read, it has to be read along with the FDI policies as well as the non-debt regulations part of it, because both needs to be fine-tuned to understand what are the applicability or what are the nuances to be applicable for the specific sector or investment which is to be done. And RBI has authority to issue master directions, the press note, the circular which is there. So hence RBI also becomes that crucial. These are the key comes into play because CCI is coming into play when it reach a specific thresholds which are being mentioned in section 5 and 6 of Competition Act. If it's required, then definitely prior approval of CCI regulations in the background of how the evolution has taken place, along with the changes in the sector being open for the investment, the evolution of the regulations and rules which has taken place for the foreign regulation.
Okay, thanks, Vishal. Yeah, Prashant.
The recent developments in FDI, which is as per amendment rules read with press note 3, are prior government approval is required in investment related to subject to condition, which is investor is incorporated or registered in country that shares a land border with India, beneficial owner of investment in India situated in any country that shares a border with India, beneficial owner of investment in India is a citizen of any country that shares border with India. Recently, 347 FDI proposal received from countries sharing land with India. Out of that, 66 were approved and 193 were rejected. The countries who share border with India are China, Bangladesh, Pakistan, Bhutan, Nepal, Myanmar, and Afghanistan. The total investment of this 66 proposal were 13,624.88 crores.
Press note 3. Thanks, Prashant. Thanks for this one. This is the most crucial aspect as of now. The press note 3 of 2020. Why it is? The reason it is that it restricts the investment from land border sharing India. So there are 7 countries which share the land border with India. Now, what prescribed, what exactly it says that it's not saying that it is not been permitted, which is that it is permitted, the investment are permitted, but it comes under an approval route. And when we say approval route, it has to pass through all the ministries, the Ministry of Home Affairs, the Ministry of External Affairs, the Union Home Ministers, and then finally an approval comes into play, which is there. And being China, the maximum investment by China are into all the startup companies, tech-based company, which is there, even the manufacturing hub, which is part of it. So that was a restriction which we imposed, which was there. The reason, as we know, because of the COVID pandemic, all companies were in fragile state, and there were possibilities of either a takeover opportunity by a Chinese firm, which was being very much been there was an apprehension of it, which is there. Hence, this was being imposed as a part of it, and government wanted to control the situation which is there. The interesting part in this particular press note 3 is that it says beneficially owner. Now, what is beneficial owner? That's a question. That's a question to be answered, which is there, to be interpreted, which is there. Because beneficial owner, when we say, whether we refer Companies Act, whether we refer Prevention of Money Laundering Act, whether we refer RBI KYC regulations, which is there, different thresholds are there under it, which is part of it. If we refer Companies Act, 10%. If we refer PML Act, it's 25%. If we refer KYC regulations, it's give a separate threshold. And there are cases where even 1% is considered, because it says that transfer of security, whether if present or future, will also get covered into it. So the existing investment are whole. That is one of the thing. Existing investment are also can't be transferred. Second, the fresh investment are also, which has required, will also require an approval part of it and needs to through an approval route. So this is a very interesting segment and interesting fact which has come into play, whereby it has been mentioned that, and as Prashant highlighted, there were 347 FDI proposals which were being given, which government has received in span of last 2 years, part of it, but only 66 has received an approval. 66 also, and the approval which has been received are into the key regulations and key sectors area, which is there, out of which service oriented are almost 50% consist of a service and service oriented sector where the approval has been given on it. So this remains a point of discussion, the definition of beneficial owner, the thresholds, how implement and how government will take a view on this, how to implement further, whether relaxation will be given or not, depends upon the geopolitical situation also and the impact of COVID pandemic also.
So Vishal, in this beneficial owner, so what is the general practice people take it? They bank on which definition of beneficial owner?
So as of now, when we see Section 89 of Companies Act clearly says a beneficial owner who, basically what does a beneficial owner mean? Beneficial owner mean that a person whose name is there as a benefit under the register of members as a beneficial owner, and there is someone the member name is in register of members, but the beneficial owner. So there is no limit being taken. There are different views, different school of thought has been applied to it, and even one person is considered to be a beneficial owner. There are views. Different ADs has taken a different view. Let me tell you, ma'am, it's because at the end of the day, everything RBI says go to AD says go to RBI. It's a passing the ball game which gets played into it, and authorized dealer finally says that let's take a declaration. They usually ask for a declaration to be taken from an investee company and even from an investor that it is in compliance of press note 3. So there are different views. Some school of thought are taking a view of 1%, 10% also, which is there. But if you say to be on conservative side, because when an investment is done, we don't want the investment to be a void investment at a time which is there. Right. And being the sensitivity which is associated with it, so we prefer, even if it's a 1%, let's go and take an approval or let's seek a clarification for that extent, so that we do not want the title of share or the title of investment to be defective at right from the stage of the start when the investment is done.
But I think here, rather than beneficial owner, our Companies Act, UBO, ultimate beneficial owner, is of main concern, according to me. Because in between intermediaries there, you are concerned with ultimate beneficial owner. If we check that way, I feel that is the also should be the view. What is your?
You're actually right, Dipti, because even if you see in the Companies Act also, what is happening when you are talking about the related party transaction, ultimate ownership who's holding the company is required to be declared here. Although there are intermediary steps of, steps from subsidiaries, parent companies, etc., who's the ultimate ownership. Yeah, especially when you are talking about the cross-border investment, etc., another thing and all, the investment made in somebody else's name as appears that who's the real owner, who's not known.
Yeah.
But ultimately the ownership is lying with somewhere else. That is where the government wants to get into.
Yeah, actually,
because there are different way of coming in the different countries,
right,
like the Mauritius route and things like that. So the whole of that, this regulation has been actually brought to know who's the ultimate beneficial owner, where the benefit really goes. That is
I think that should be, it's everyone's view, but it's my personal view that UBO is the right in the spirit. It is the, I think we can bank.
That's right, ma'am. UBO is, that's the intent to know who is the ultimate owner, who is the
That
ultimate
is the
person who is
real
controlling
intent.
it. Yeah, that's the intent to understand from it. But the reason, then it has to, they should have clarified, because there were
Yeah, of course. That's why we are
yeah,
talking
yeah,
about
correct. In fact, the day when it came, which was, if I recollect, it was 17th April 2020, and it got notified on 22nd April 2020, which is there. The day it became effective, immediately there were a lot of representation between MEC, because at the time of transaction, which we do at times, we are in middle of transaction and we get a shock that this is not is permissible. What then? How to route it? What are the alternatives available? How to structure it? Because then that is the question, and there were a lot of clarifications being said, representation which were being made via FICI, via CCI also, but still that is clarification has not been given. So authorized dealer, ultimately the balls goes to authorized dealer, and authorized dealer asks for a declaration to be provided at the time of investment itself, which they take a representation to that extent, which is, in fact, I will share a personal experience. One of the structuring which we were doing it, the structuring was routed through China, which was there, but at the end stage, which is there, at the stage of when the investment was about to kick in, that time this regulation came into effect, and the whole investment route should have been, we have restructured it, and we restructured through Australia and Singapore, and then the investment was being done because of these restrictions which were being imposed. So that is the impact. It has a massive impact across part of it, and already there are whether you take Paytm, Byju's, everyone is the Chinese investment are there in all the unicorn startups which are there. Part of it. It is not that it is not. So it has already invested a lot, but that investment is also being stuck right now. It is in limbo till the time we get, and when we see in 2 years span of time, 347 application made and only 66 are being approved. So that gives the percentage of acceptance also, which is being looked by government as a message which is being given, that 66 is only which has been approved to it, because we already have in pipeline 75,000 crore applications. That is an amount which is waiting for investment to be made in India, but we are not accepting it. So that's the criticality in this, and the
but
of
there is a reason, of course. I know they are also knowing when they declared UBO. They know that UBO can be very well convenient, but they want to understand the structure with this pending approval, that what kind of coming. So I think they are also studying and viewing.
Yes, that's right. The layering structure, because the corporate web which gets created and the layering structure which comes into play, that becomes more crucial into the part whether how to structure ultimately and how to go through it.
Right.
Correct. In the past, I know there are cases which were there. They formed a trust. The investment was actually made from the trust. The real ownership to the trustees are actually a beneficial owner who are somebody else. So this also has come to the light in the past.
Right. Okay. Thanks, Prashant. Carry on.
Now, ED category 1 banks roles and responsibilities. So what is ED category? It means that scheduled commercial, state or urban cooperative banks as which is authorized under section 10(1) of Fema to undertake capital and current account transaction. Its role is to take FCTRS form. Hello, am I audible?
Yeah, now you are audible, but one thing is that you must actually also tell that we are the people, we are not able to directly deal with either the Reserve Bank of India and other people. That authorized person to deal with is actually authorized dealer, to whom with all the things has to be done. Authorized dealer is the person to whom all the document scrutiny, everything is being done. So the parties have to deal only with the authorized dealer. That I think probably you have to, I think. Yeah.
Yes, as Balasa said, we have to deal with AD banks, AD category 1 banks rather than RBI directly. So AD category 1 banks are the route for FDI. They play a very important role. Like form FCTRS is to be submitted to AD category 1 bank. KYC for receiving remittance is to be submitted to KD category 1 bank. Open an escrow and special account for non-resident corporates. AD category 1 can allow remittance of security sold and winding up proceeds.
Prashant, 1 minute. Vishal, there is one question. Panel, there is one question. Is press note 3 is applicable for all the schedules of NDI rules or only for investment under schedule 1 of the rule?
No, it is applicable now. That's an interesting question which is there, because Schedule 1 says about the investment part of it, but what we understand that it is applicable across, it is not only limited to Schedule 1, because that clarity is not there. If we see Press Note 3, the language which has been mentioned in Press Note 3, it says that any investment from the land border in India it has to be come through government route. It does not specify categorically whether it's only for Schedule 1, Schedule 2 or Schedule 3.
Right. But I think they have covered everyone, everything, because it is easy
Schedule
target for
2
each
covers the FPI
industry.
limits which are there. So, right.
Right. Thanks.
In fact,
Yeah.
ma'am, just to add upon, there is one interesting case which is there when for this question which has been raised. It's an interesting question. The reason it was being brought, because if you recollect, there is an article which says that when this notification came into effect, there were Chinese investors who were trying to take a stake in HDFC Bank. And HDFC Bank, and in HDFC Bank, already they had taken a stake of 0.5%, which was there. So to avoid that thing, so to answer this question, it applies to all the schedule and not to one schedule.
Yeah. Yeah, thanks. Yeah, Prashant, carry on.
So sectors in which FDI is not permissible is gambling and betting, business of cheat funds, lottery business, nidhi companies, real estate business, trading in TDRs, manufacturing of tobacco and cigars, foreign technology collaborations. The permitted sectors are which I have not taken the automatic sectors which under 100% FDI cap. I've just taken the sectors which requires approval for government, or some part of requires approval from government. At air transport services, which the FDI cap is 100, subject to automatic up to 49, and beyond 49 is government route. Private security agencies is 74%, but automatic is up to 49, and beyond 49 it's government route. Telecom sectors, it's the FDI cap is 100%, but automatic is up to 49, and beyond 49 is government route. Multi-brand retail trading, it is just 51%, and through up to a government route. Banking public sectors is just 20% through a government route. Pension sectors is 49% through automatic route. Banking private sectors is 74%, automatic up to 49, and beyond 49 it's government route till 74. Power exchange, it's 49%, automatic route, but it applies only will hold more than 5% in equity in these companies. Banking public sectors is 25% of government route. Pharmaceuticals, in Greenfield it is 100% automatic, but in Brownfield it is 100%, subject to the condition that it's up to 74% automatic, and beyond 74% it's government. Infrastructure companies in securities market, the FDI cap is 49, and it's through automatic route. In defense, it's 100%, but automatic up to 74, and beyond 74 it requires government approval. In print media, for newspapers and periodical dealing, it's 26% to government route. For publications of Indian editions of foreign magazines, it's 26% to government route. For publications in the scientific and technological magazines, it's 100% through government route. Publication of facsimile editions of foreign newspapers, it's 100% through government route. Broadcasting, it is 49% through government route, but uploading and streaming of news and current affairs through digital media is 26% through government route. Insurance is 74% through automatic route. Now the key sectors.
Prashant, just a moment.
Sir, again the question, Greenfield or what is it?
Yeah. Sure. We'll address the question and just go back to the sectorial limit ones. So these are the sectorial limits which have been mentioned. In addition to sectorial limit, there are other conditionalities also which comes into play, which is there. These are the sector. This is sector specific, and other conditionalities. Either it's a minimum minimum capital requirement or applicability of certain investment which is to be done either through sourcing from India, specifically from SME sector part of it, or there is a requirement of any specific product or sector where the focus is required. So there are other conditionalities also get associated with this. It is not only that it is the limit which is being prescribed, along with limit, there are other conditionality to look into it, which is there. Now, when we say air transport, recently government was trying to divest the Air India business from last 5 years. There were various attempts which were being made. Eventually, our own homegrown Tata group had taken the part, but the divestment process allowed 100% investment in Air India, which was a liberalization move which was being taken by India for it. Then there was oil and in natural gas and oil also there has been a relaxation which is being given, whereby in fact there is a divestment which is expected in BPCL also in coming years, which is there along with it, with part of it. IDPI, the process has already begun to privatization of it, and in the budget also there was a announcement which was being made whereby 2 public sector bank will be made privatized and even a 1 general insurance. So there is a lot of liberalization which is expected to kick in because of the sectors, the way the attraction is there across part of it. And not, I would like to mention about IBC, how IBC is helped at the linkage between FDI and IBC. If we see the successful IBC case right now is SR Steel. And SR Steel, the investment which is being done, the investment is done by ArcelorMittal and Nippon. It was a JV which was being formed. It was a JV under FDI which was being formed, whereby part of it. Then the case of Jet Airways. We all know what the turmoil where Jet Airways has gone through it, and where the acquisition which has been done but with. So it has linked, it's a distressed assets also. FDI is not that it helps only to grow the future part of it, the distressed assets which are there, that it helps the distressed industry also. It is a Diwan Housing Finance also we can name, but it is again taken by home ground pyramid capital which is there. So that's the advantage of FDI which comes into play for the existing industry, the distressed assets, and even the future. In the specific question, what's the difference between greenfield and brownfield? That's a classification which is given under pharmaceutical part of it, where in the pharmaceutical sector gets divided into medical devices and other sector. Greenfield means it's a fresh investment whereby you purchase the land, you set up the projects, you set up the whole new investment kits in which is there. Brownfield means it's an existing company, it's an existing manufacturing hub which is already there in an existing in the existing setup. The investment is being occurred. That's a difference between greenfield and brownfield part of it. And under the brownfield, in the existing setup, it's only permitted up to 74%. Beyond 74%, we need government approval, which is up to 100% is allowed in the pharmaceutical sector. But there are other conditionalities. The most critical part in the pharmaceutical is that non-compete fees are not allowed. If we read the schedule 1 of pharmaceutical sector, it clearly says the non-compete fee, because that is a very important component when the transaction gets finalized, where the non-compete fee is permissible or not. That is not what is permissible in the pharmaceutical sector. There is a NELM product. NELM products are the national list of essential products, which if investment is done in pharma, in a greenfield project or a brownfield project, then there has to be a specific focus on a LELM product which has to be part of it. And in the R&D, because pharma is all about R&D, which at the end of the day, so the investment in R&D for the tune of 5 years out of 3 years, the average which has to be there, which has to be highest. So that's the what is required at the time of the greenfield and brownfield investment in pharmaceutical sector.
Yeah. Okay. Prashant, carry on. Thanks, Vishal.
Yes.
The key sectors are e-commerce, single brand and multi-brand retail trading, asset reconstruction companies, and insurance. So condition for investment in e-commerce is only B2B business are eligible for FDI. 100% FDI is allowed in e-commerce, but an e-commerce entity will not permit more than 25% of the sales value of financial year basis affected through its marketplace from one vendor or group companies. The conditions for investment in single brand retail trading is
1 minute. There is a question that whether this press note is also applicable to ESOP. The employee is located in the, it is not for ESOP. As per my, just clarify, Vishal.
No, it will be. The reason is that there are three criteria which are being mentioned in the press note 3. The three criteria which are being mentioned is the beneficial owner, whether it's a citizen of that particular country or whether it's situated in that particular country, because at the end of the day, these are options gets converted into shares. Security needs to be issued. If you are issuing a security to a person who is a citizen in India or who is situated in any land border country which is there, then definitely it will kick in. So you will need to keep the option up in abeyance till the time there is further clarification.
Okay. Okay. Thanks. Next person.
so conditions for investment in single brand retail trading. It's it's up to 51 sourcing. Beyond 51, 30% of the sourcing of the value of goods purchased will be done from India, and it's required government permission for FDI exceeding 49% in a company. FDI in
There is a question whether sectoral limit applicable to all forms of foreign investment, FDI, FPI, FPCI.
Yes, yeah, it is applicable to across part of it, and in fact, FPPI has a separate limitation on the SEBI FPI regulations also, which is there, which is a 10% per limit and overall cumulative 24% limit, which is there. But the sectorial limit is applicable across part of it.
Yeah, thanks. Yeah, Prashant, next.
Conditions for investment in multi-brand retail trading. It requires minimum amount of $100 million and 50% of which shall be brought in and invested in backend infrastructure in the first tranche within 3 years, and at least 30% of the value of procurement of manufactured processed products should be from Indian micro, small and medium enterprise, which should have a total investment in plant and machinery not exceeding $2 million. The retail outlets may be set up only in cities with a population which has more than 10 lakh and may cover only the areas up to 10 kilometers. And state and union territories have freedom and discretion to formulate their own policies. Some of the states are Maharashtra, Delhi, Haryana, Rajasthan, and more. FDI in ARC, which requires a person resident outside India should invest in capital of ARC, which is registered with RBI, and the single foreign institutional investor and foreign portfolio investor shall be below 10% of the total paid up capital, and it should invest only in the security receipts issued by asset reconstruction company. Foreign direct investment in insurance is allowed to insurance brokers, third-party administrators, surveyors and loss assessors, insurance companies and other insurance intermediaries.
Listen, just wait. Yeah. Okay. FDI is there of insurances. Yeah. Okay.
Should I continue, sir?
Yeah. So insurance, there are two parameters which are there in insurance. It is insurance and intermediary of insurance part of it. In intermediary, it's 100%, which has been opened up. Insurance by far it's 74%. And the journey of insurance began long back in 2015 when the sector got opened up for 26% to 49 and further 49 to 74. Recently, in this of 2022, which has been come, whereby we see the way forward for LIC IPO is been given, and where the 20% investment of an FDI, FPCI has been FPI has been allowed, which is there. So that is a sector liberalization point, because that's a huge for LIC part, and to give a way forward to LIC from an IPO point of view, the clarification which has been given, in fact, the circular which came into effect, FDI notification is yet to receive for that particular thing. Insurance being low penetrate in India, the investment of 74% will be a boost to the sector in a way. not from a technology point of view, from the product offering point of view also, in the way the insurance company, because in India, the focus of insurance is more as a bank assurance. Bank assurance is that bank which are running insurance in India, which is there. If you see out of the insurance company, almost 90% of insurance company is a JV with bank, which is there. So that is what flavor of insurance and the importance of being.
So someone is drawing something. Just a second, sir. Manjiri, please delete the things. Should I continue, ma'am?
Yeah, please.
Yeah, you continue.
Okay, ma'am. The conditions in FDI for insurance are it should be 74%, but the insurance company should be registered with IRDIA, and insurance company should be received through banking business should be more than 50% of the total revenue.
Just 1 minute, Prashant. There is a question in the chat box which says that whether there is a difference between general and other insurance for FDI.
There is no difference for it. It's an insurance sector limit which is there. Insurance gets divided into life, general, and composite. That's life and health part of it, which is that. So there is no specific distinguish between. So the limit applicable is both for general and life.
Okay, thanks. Carry on, Prashant.
Pursuant to such foreign investment, the insurers must ensure that the majority of directors, majority of its KMP, and at least one of its chairman, managing director, or CEO are resident of India. Fintech. As Fintech is one of the major source of FDI flows in the recent times, as Vishal sir mentioned earlier, it is increasing day by day, and the four major segments of Fintech are InsurTech, WealthTech, payments, and lending. As there is no unified code for Fintech in India, foreign direct investment is 100% automatically under automatic route. Recent investment in Fintech includes Cred, BharatPay, Grow, Policy Bazaar, Paytm, which are definitely the unicorns in Fintech. India received the highest ever total foreign direct investment inflow of $81.72 billion, up to 10%, up from 10% from 2019. The regulatory bodies for Fintech are Reserve Bank of India, SEBI, IRDIA, MCA, and Ministry of Electronics and Information Technology.
So just wait, Prashant, Prashant, just go to the previous. Yeah. So Fintech is a flavor of investors. It's a favorite investment avenue, which is there. And as Prashant lightly highlighted that there is no specific codified law as of now specific to Fintech. Definitely the law is there, it applicable depending upon the what services which are being provided by Fintech. For example, grown if Paytm comes into a payment bank's part of it, or the Paytm comes into Paytm X through an NBFC also. So RBI does come under the purview of RBI directly, which is there, and we know the impact which has been done because of the data localization point of view, and the notice which has been issued to Paytm in that sense. So it's sectorial limit, sectorial regulator comes into play, no codified specific law definite which is there. If it's an insurance tech, IRDAI, if it's broker part of it, Zerodha, which is also an unicorn, then it's SEBI, sub broker regulation comes into play, WealthTech also SEBI, payment, RBI, Payment and Settlement Act comes into play, lending, NBFC comes into play. So it depends upon the nature of part of it, what Fintech plays. But let me tell you, the Fintech adoption which India has done over the years is the highest ever achieved by any country in the world, which is is there. So in the fintech revolution, which started from 2016 to now, and what we have seen, the startups in fintech and also the established player, because technology has become a key enabler for a fintech part of it, and we are taking this globally. It is not now only restricted to India. It is the model which has been successful in India, which has been now getting implemented across the globe. That is the impact of the fintech industry which India will have.
Prashant, whether the
Yes, sir.
fintech will include also the cryptocurrency like Bitcoin?
Yes, sir.
So the crypto is there is an ambiguity on it because it has been loose and which has been given. No doubt, Supreme Court, there was a judgment by Supreme Court which says that it is not been prohibited. RBI is not prohibited, but RBI is yet to take a clear stand. In the budget, they defined digital assets. This budget 2022, which was been, they defined digital asset, but did not use the word crypto per se, which is there. So crypto will get covered under fintech, no doubt about it. But whether crypto is legalized or not legalized, that's a question which needs to be answered, or that's a question which needs a further deliberation required part of it. But crypto per se will come under fintech for sure.
Yeah, you are right actually, because fintech, when you talk financial technology, will automatically include the cryptocurrency. But only thing is, as you rightly say, in the budget also, they have very tactically worded only the what you call digital currency. They are not named as the crypto or something like that.
That was a smart move which was done rather than giving, and they only tax to that. They have just mentioned it will be come under the bracket of 30% tax, which will be there. But the interesting part is that whether it legalized, because that was the deliberation out of it was that if it is tax means it's liberal. It is a valid currency form of it. Then only you are taxing. That was what was the conclusion. But there was a statement clarification that still government and RBI is under consultation, and they will come out whether to give a clear picture of it, that whether it is so. Right now, crypto from a legalist point of view, it is in limbo. From India point of whether it is there, no doubt globally developed countries have accepted crypto as a form of currency which is there. And what we see in Ukraine also, the current geopolitical tension which is going on, there are a lot of donations which are being made through crypto part of it. So crypto is considered as to be a valid, but only in a developed countries. Now we'll need to see what stand is being taken either by India or other developing countries also, because that will make a move about how to, because crypto at end of the day, if you and me want to invest, we can invest in crypto because the crypto exchange are available, but then it comes under LRS. When it comes under LRS, the limit of LRS becomes applicable. But the best part is that the window for investment is open, but when you want to repatriate, when you want to liquidate your investment, then that's a stop. Then you can't do it. Then it is held back with the bank, the amount. So that is the interesting part. So when you can invest, but when you want to liquidate it, whether you can do or not, and what will be the implication of that, that is thing which need to be looked into it.
And crypto is really actually giving tax and giving some government tax to crypto itself was a bold movement by Indian government, looking at always the conservative approach India has taken.
Yes.
Thanks. Yeah, Prashant, carry on.
So what are the instruments that can be used for in FDI? It is equity shares, fully compulsory and mandatory convertible preference shares and debentures, warrants and partly paid shares. So if an investor wants to invest, what is better for an investor, equity shares or preference shares? So the type of investors generally use equity share as it gives them decision-making control in the company, but in generally preference shares are subscribed by institutional investors and provides them a preferential and protection. The nature of return that equity share gives fluctuates and depend upon the distributable profits. But in case of preference shares, dividends are fixed and at a fixed rate. Right to receive dividend in equity shares depends upon the company, whether it wants to distribute dividend or not. But when it is distributed, preference shares are given the first preference and have the right to dividend before equity shares holder. Right to receive surplus capital during liquidation. Entitled to repayment, equity shareholders are entitled to repayment of capital invested after all the financial creditors and preference shareholders and do not have any access to the surplus capital on winding up. As preference shareholders are given preference over equity shareholders during the voting rights, equity shareholders have entitled to vote on every resolution passed, but preference shareholders are entitled to vote only on those resolutions in which it affects the rights.
Yeah, the basic thing is here, the equity shareholders are getting their return on the basis of the profit. That means, apportionment of the profit. But whereas in case of the preferred shareholder, the return is actually under the accounting standard, you might have aware, it is actually a financial charges. That's all. It is not depending upon the profit because the pre-committed. So it will be treated as a long-term borrowing, and also it will be financial charges. That is the difference here. Yeah.
Okay. And to add what sir said about it, this is the first step of it, of a structuring part of it. When an investor comes and say that they want to invest in, what's the instrument? If whether you represent a company or represent an investor, so what has to be distinguished is that what is the nature of instrument to be given, whether it's equity or CCPS. Equity comes with a risk, inherent risk. It's an equity owner. As sir rightly said, it's a profit distribution which takes place at the end. Equity comes last in order. Part of it. Preference, as the name itself suggests, it's a preference over equity, which is there. That's the CCPS construct which comes into play. That's an investor will always prefer to invest through CCPS model, which is there. There are several inherent advantages of CCPS investment which are associated with it, which is there, which comes into play. And the reason it is there, one of the critical expense with that it can be contractually agreed between an investor through a shareholders agreement. It can be contractually agreed between a company and an investor how the voting parameters will be considered and how the shareholding will get reflected on fully diluted basis, because that is what ultimately determine and which gives the skin in the game for the investor for investment from CCPS model.
Yes, Vishal, you carry on, please.
Sure. So that is what is the investor prefers CCPS model over an equity, no doubt. And depending upon what, whether it's a investment through financial instrument, whether it's a strategic investment which is to be done, and the interesting fact which is there that there is no assured rate of return. We see when we see the non-debt regulation says it's defined the term it defined the term equity instrument clearly says that there has to be no assured rate of return. That we will discuss in detail when we discuss the Tata Docomo and NTT case which is there, the Tata Docomo Power case which is there. We will discuss in detail what exactly the term assured return means and what was the game changer in the Tata case.
Okay. Prashant, carry on.
The methods that can be used under FDI: issue of right and bonus shares, share swap, acquisition of shares under scheme of merger, amalgamation, demerger, and we can also do it to sponsor ADR and JDR issue. When instrument is issued, it should be issued within 60 days, and if it is not issued within 60 days, the amount of consideration shall be refunded within next 15 days. The time limit allowed by RBI is 180 days, but MC has allowed only 60 days. So the company has to issue the shares or instruments within 60 days. Repatriation and remittance. Company needs to repatriate when the sales proceeds of security, the proceeds of winding up and liquidation of company, repatriation of dividend which is given by company, repatriation of interest like on debentures, on preference shares. The modes of payments allowed for receiving FDI in India. This is how company receives FDI: through inward remittance, debit to NRE and FCNR account of person, debit to non-interest bearing escrow account in India, conversion of royalty, lump sum, technological know-how, fees due for conversion or conversion of ECB, conversion of pre-incorporation expenses incurred by non-resident entity up to the limit of 5% of its capital or 5 lakh US dollars, whichever is less. Conversion of import payables, incorporation expenses can be treated as consideration for issue of shares with the approval of FIFP.
So,
If the shares or convertible debentures are not issued within 180 days from the date of receipt of inward remittance or date of debit of escrow account, the amount shall be refunded, as we read earlier. It's for RBI. The procedure for direct investment in India through approval route, the first application is to be made through Foreign Investment Felicitation Portal. The application has to be submitted online on the portal with the list of documents which is given in the standard operating procedure. DIPP would scrutinize the form online and transfer the form to the concerned departments under which the FDI is required and will take only 2 days. The time limit for the process is maximum 10 weeks and additional 2 weeks is given theoretically, but in general it takes 6 to 8 months for every approval.
Prashant, just go to the previous slide. We'll just quickly summarize on this part. The SOP was a process. Earlier, the application was supposed to be done to FIPB. FIPB would get got wind up through Union Budget of 2019, and then it was being replaced by FIFP, that is a Foreign Investment Facilitation Portal, whereby we need to make an physical online filing as well as a physical filing has to be submitted with couple of copies to the FIFP, and FIFP gets FIFP coordinates with other ministries, the concerned sectorial limits, and in fact even with the Ministry of Home Affairs and Ministry of External Affairs, the coordination has been done. And DPIIT is the body. DPIIT comes under Ministry of Commerce and Industry, which regulates FIFP and the whole process. The whole process usually takes time because SOP says that it's limited to 10 weeks part of it, but 10 weeks from the last query which has been raised. And once the query information has been asked, there are certain clarifications, additional queries which are being raised and which needs to be addressed to it. And on a ground level basis, it takes to at least 6 to 8 months to complete the process which is there. And in press note 3, it has almost taken 2.5 years to get a clearance of only to 66 proposals which were being cleared. So that is the way when it goes through an approval route. But again, approval route only consists of 2% of FDI, 98% consists to an automatic route.
Okay, thanks. Prashant.
Reporting of FDI. When a person invests in India, the company should report to the regional officer of RBI within 30 days from the date of receipt. And the company is required to file FC-GPR form within 30 days from the date of issue of share. When transfer takes place, the transferor or transferee is required to file FC-TRS with AD category 1 bank within 60 days from the date of receipt of consideration. When it relates to non-cash, the shares issued against conversion of ECB have to be reported to regional officers concerned of RBI in FC-GPR and ECB2. This is, we all might have known this, FLA, annual return of foreign asset and liability. Every Indian resident company or LLP receiving FDI or had made FDI in previous financial year has to report FLA on and before 15 July of each financial year. The steps to file FC-GPR form. First, the company has to register for business users, login, then it has to log into the firms, then it should log in into SMF and reach out to your workspace, select the return type, then put the details of common investment, then issue details, what the company has issued, to whom it has issued, the foreign investment details, the amount of issue, the particulars of issue, the shareholding pattern after the issue, and the last thing, the company needs to submit the form. Documents required. It's required declarations, certificate from company secretary, appointment of authorized representative, certificate that the resolution that states that the company has made him appoint authorized representative, valuation certificate, board resolution, letter of debit authorization, and KYC with FIRC. The late fees for FC-GPR is 1% of the total amount of investment, subject to minimum 5,000 but maximum 5 lakh per month or part for the first 6 months of delay and twice the rate. The compounding: if a company has failed to file something, it can be compounded to regional officers of RBI, and the compounding needs to be submitted with demand draft of 5,000 rupees. An application for compounding filed with RBI for contravention is required to be disposed of within 180 days from the date of receipt of application. The major countries from FDI, from which India receives FDI, is Singapore, which is 34%. Then it comes USA 20%, Mauritius 19%, Switzerland 18%, and Cayman Island it's 9%.
This is Prashant. Just go to the previous slide once.
Yes.
No, the one where we received
This one, sir?
the distribution, the countries from where we received the
Oh, yes,
FDI.
yes.
Yes. Okay, so this depends upon the treaty which India has signed. That is a bilateral treaty for the investment part of it, and investor prefer treaty shopping for it because it gives an advantage for it. That is the reason we see that why it is only specific to Singapore, USA, Mauritius, Switzerland, Cayman Island part of it. It is not that other sectors or other countries is not permitted to invest. It is investment, but the investment from a tech at the end of the day, if an investment is to be done, it has to see both levels point of view. It has to be from both perspective, from a taxation point of view also, and from a structure point of view also. From a taxation point of view, why it is advantage to a route through a tax haven countries, which is that is what is the crucial aspect which determines the investment part of it, and why it Singapore constitute to maximum 34% of an FDI flow which was being done. The reason of the tax treaties which are being signed, the capital gain tax which comes into play is it's not payable in India, it's payable in Singapore if the investment is routed through Singapore part of it, or even Mauritius. So government has widely, there are bilateral treaties which has been entered with almost 74 countries which is there, but there are few countries still where the restrictions are not being imposed, but government has still visited. Earlier Cyprus was the flavor of the investment which was been done. Cyprus and Mauritius were part of it, but then there were several restrictions which were being imposed earlier has been relaxed, and that taxation point of view comes into play. So that's the one of the critical reason why, if we see the contribution of an FDI or the investment route through Singapore, Mauritius, or Switzerland is more compared to other countries. Netherlands is also a country which is catching up, and a lot of investment is now routed through Netherlands also.
Okay, thank you. I'll request panel to take a questions in chat box also. If we can take it.
Sure. I think there is a question. Is reporting of RBI is required both in case of automatic and approval? Yes, it is required in both case, which is there. And approval route will have additional conditionalities also, which is there. When an approval is being given by DPIIT, at that time it comes with an additional conditionalities which has to be fulfilled. So reporting is required to both. Then there is a requirement that if net asset method is adopted by registered valuer for transfer of shares from non-resident in case of FCTRS, what is to be considered as an international accepted part. So this international accepted part, which is from a pricing point of view, which has been mentioned, it's open up. It's not narrow down the approach which is being taken. So net asset is one of the matter for valuation to be done. Now the valuation can be done through net asset method. If it is accepted international or not, that is the question which needs to be determined, which is, to my belief, it is accepted method which is there part of it, but it will leave to the discretion of an RBI to decide what whether it will be constituted or not. But because the terminology which is being used under the regulation is very wide and open, and it does not say that any specific method to be considered for valuation part of it. And definitely the pricing guidelines kick in when, if the requirement, whether the transfer is between an R to NR or the issuance of shares is to NR, the what pricing guidelines has to be fulfilled as per the non-debt regulations will be required to be done. So to answer the question, net asset method, yes, it is international accepted, but the discretion is always with RBI to say no, that it may not be considered.
Okay, thanks.
Okay, and there is a question on highlighting automatic route for e-commerce base. So
Right.
e-commerce is a very wide term. We will need a separate session to discuss the
Session.
e-commerce session on it, because there are a lot of case studies, there are a lot of structural point of view from an e-commerce segment, and which is required. Just to give a glimpse of it, what does e-commerce basically bifurcate the B2B business part of it, where 100% is allowed. B2C is not allowed, not even under approval route which has been allowed. Part of it's a B2B 100% marketplace model. Yes, there are certain conditionalities which are being mentioned. Conditionalities of 25% of sales should in a one specific financial year should be limited to that one entity which is there, so that there is no concentration of particular sales or revenue from from more than 25% of any other known entities or group entities, to name it, which is there. Then there should be no exclusivity arrangement. To go back, if you see the evolution which has been done in e-commerce in 2017, if you go to 2015 Amazon ad or Flipkart ad, you will find the word exclusive was always being mentioned over there. That's a brand tie-up which has been done. OnePlus exclusive only on Amazon. There specific models which were only available on that. But now due to the amendment which has come into effect, the word you will not find the exclusive. If you compare the advertisement which was being done prior and now, you will see the difference of what regulation has made into play, because exclusivity is not been permitted, whether it's B2B marketplace model which is there, because inventory based anyways it's not permitted. There is not even a single person FDI is permitted into it. But that is what is the nuances of e-commerce marketplace model which is there. But to delve in detail, definitely we'll arrange a separate session to discuss in detail about the e-commerce segment only.
Sure. Thanks. Thanks,
We
Vishal.
have taken your suggestion. I think probably we can have one session on e-commerce separately later.
Sure.
Thank you.
Right.
Thanks.
Thanks. Yeah, Prashant, carry on.
The major sectors in which FDI inflows are absolute high. Computer and software, hardware, it's 27.87%. Automobile industry is 15.84%. Service sectors contributes 10.12%, and education is 7.122%. Now, there's a case study on entity Docomo and Tata Sons case. It is in 2009, Docomo acquired 26% stake in Tata Group, owned Tata Tele Services. Tata Tele Services failed to meet the key performance criteria as envisaged in the shareholders agreement that was between Tata Docomo and Tata Group and Tata Tele Services. The Japanese telecom major exercised an exit clause that gave entity that right to sell its TTSL shares back to Tata Sons at 50% of the acquisition value or the fair value, whichever is higher. In July 2014, Docomo exercised the option. The fair market value of TTSL stood at 23.34 per share, much less than 50% of the acquisition price, which was 58.05 per share. So Docomo demanded rupees 58.05 per share. Under Fema, do not permit guaranteed returns on such equity investment. Since Docomo and Tata Sons could not agree on the exit price, Japanese Mobile carried move on to LCIA in January 2015. It ruled that in favor of Docomo, and Tata directed Tata to pay $1.17 million for breach of contract. In Indian arbitrator law provides that under section 48 subsection 2 clause B, that the enforcement of foreign award may be refused if the court finds that it would be a contrary to public policy of India. LIC held that Tata to be breach of its primary obligation and ruled that Docomo was entitled to damage. Tribunal directed Tata to buy back TTSL shares and pay Docomo $1.17 billion. On July 7th, 2016, Docomo moved to Delhi High Court asking for enforcement of arbitral tribunal. Tata Son has filed affidavit in response of Docomo petition. Tata Son argued against the enforcement of the award as it would be in violation to the Indian public policy.
Okay.
In-
I'll just go to the previous slide once. We'll just quickly summarize on Tata Docomo case, which is there. So this is a very interesting case, which in fact had led to several amendments into the policies of FDI and the non-debt regulations also, which we can see the definition of equity participation part of it. So what does Tata Docomo case use? What was the key takeaway out of it? The key takeaway was that it was a JV between Tata and Docomo, which was being formed as a JV in a telecom sector part of it, and they're entering into a shareholders agreement. One of the key parameters of the shareholders agreements were to scale up the business activity, and the performance parameters were agreed between the parties. And in the event, if Tata is not able to achieve that, then what will be the consequences of it? The consequence was that Tata will provide an exit to Docomo from it, and at what price? That is the point of discussion, and that was a moot point which came into play, that at what price it will be provided an exit. The exit was supposed to be provided as a higher of the fair market value at that point of time, or 50% of the investment done by Docomo. Now, when they ask for an exit at a price which is there, then it's a form of a assured return, that you are asking for an assured return on your investment part of it, which then with it. There are two ways to look into it. Investor will say, I'm looking for a downside protection, that my investment should not go below this price. It can be looked at they are asking for a return on the investment also. So the question which came into play was that, is an assured return permissible under an FDI regulation? It was silent. The regulations were silent when the investment was done at that point of time. Hence, the route which Tata had gone through it, that if Tata obliged to pay what was being agreed under shareholders agreement, but it will be against Indian public policy, because they are giving an assured return to an investor, to the foreign investor. So to answer that question, what did Document went? Document went to LICA, to a London arbitrator, and then it was an award which was being passed. Award was primarily passed on the shareholders agreement, the terms which were being agreed by the Tata and Docomo, and on basis of that, the tribunal says that you need to honor it. They pass an order to Tata. This was agreed, and you need to honor it. And now, how you honor, that is what you need to see. But then whether it has to be honored through buyback mode, because buyback, there is a regulation which comes into play at the price which the buyback has to be done. So can a buyback be done at a specific assured price which has been agreed upon? Which to the question, we know the answer. It has to be done through a pricing mechanism at that point of time. So the move, which was interesting move, which was being done, is that the compensation was paid. The compensation was paid in a nomenclature of damages. That it is what they are asking is a damages. The damages for the obligations which Tata was supposed to perform, which was there, and it was not able to perform part of it, and there was a lack of performance at the Tata's end, because of which the loss was incurred by an investor. So they are claiming damages, and they are not claiming an assured return from the investment which has been done. And under the damages name, finally the matter gets settled through out of court settlement. Tata honored it. Tata has made the payment to Docomo part of it, which is there, and the payment was made under the name of damages and not under the name of assured return or a return on investment to Docomo. So that was a moot question which gets framed under the Tata Docomo case, which whenever an assured return construct is discussed, Tata Docomo is a case where we need to go through, and because that is the case which distinguished the thing, and in fact which rule out RBI. There were a lot of correspondence with RBI, between RBI, Ministry of Finance, which was being done, and finally the payment was being done under the name of damages to Docomo.
So it can be said that damages can be paid, but not assured return.
Yes.
Or the assured valuation.
Correct.
When you are doing. So I think it's another structuring model they have given.
Yeah, that's right, ma'am. It's a structuring model which has been given because the definition of equity capital itself now, earlier that was not, there was an ambiguity of it. Now it clearly says that any option or an assured return will not be considered part of, which is not permissible at all in the instrument part of it. But since the investment was been done way back in 2009, when it was evolving itself, the FDI norms were getting evolved. So that was a reason the ambiguity was there at that point of time. But finally, it was being paid through damages. Damages you can definitely pay. Now there's a different question on indemnity and damages, how, whether it's a capital account transaction, which is a current account transaction, which needs to figure it out. There is still a gray, very thin line of difference between them, which is required to be addressed and deliberate about it.
Okay, thank you, Vishal, for your input. Okay, Prashant.
Second case study is Praveen Khandelwal versus Spin India Private Limited, which was on 3rd March 2022, which is very recent case in which Spin India Private Limited was incorporated in July 21 and operates in an e-commerce by the name of Shopee. As an informant, it was launched in India as a mobile and web-based platform, but it is controlled by Spin 1 Private Limited and Spin 2 Private, which is registered in Singapore. These two entities are in turn held by another parent company, Spin India Spin Limited, registered in Cayman Island. It is noted that such complex structuring is in contravention to FDI policy. Some of the analysis are the informant has further allied that since its inception, Shopee has managed more than 1 lakh orders per day, which has created a dominant position of it in India. The informant also allied that Shopee offers its product and services at an unfair and discriminatory price. Informant has provided certain screenshots from Shopee website and allied that some of the products are sold at extremely low price, such as 1 rupee, 9 rupee, and 49 rupees, etc. Such tactics of deep discontinuation are allied to be in violation of FDI policy. Thus, Shopee is allied to be in dominant position and abusing its dominant position. The judgment in this case was the commission observed that Shopee had launched in the market by way of online platform in India, which already has a presence like companies like Amazon, Flipkart, Myntra, and Nykaa. The commission further notes that allegations is that Shopee is in following similar discontinued practices as allied done by Amazon and Flipkart. And it does not appear to the commission that Shopee possesses significant market power, much less dominance at this stage, as it is a new entrant in the market with the established players. The commission is of the opinion that there exists no prima facie such contravention of the provision of Section 3 or 4 of the CCI Act against Shopee, and therefore the matter to be closed forward under Section 26(2) of the Act. The major case of FDI is Future Retail and Amazon. Amazon.com invested holds 49% in Future Group. In turn, FCPL holds 9.82% in Future Retail Limited. And FCCL is engaged in business of cash and carry wholesale trading. FRL is engaged in multi-brand retail. The provision which hit in this case study is Amazon has indirectly gained control over Future Retail without government approval, which is violation with FDI rules under Fema. Analysis of the case are Amazon has brought 49% stake in Future Coupon, an unlisted firm of Future Group with the right to buy a stake in the group listed entity. Future Retail, after a few years, if the government ended the restriction on foreign ownership of multi-brand retail, Amazon, in its shareholder agreement, has barred Future Coupons from selling its asset to the 15 firms, which includes Reliance Industries. However, in August last year, Reliance acquired 30% stake in Future Group business for 24,000 crore, which now started the row with Amazon. The judgment in the case was huge. It has included all the authorities in India. On August 6th last year, Supreme Court had given verdict in favor of Amazon and held that the emergency arbiter award restraining 24,000 731 crores of Reliance and a future merger deal is valid and enforceable under Indian arbitral law. The apex court also set aside the two orders in Feb 8 and March 22nd, 21 of the division bench of Delhi High Court order, which had lifted the single judge order staying that the Reliance and future merger. The bench headed by R.F. Nariman, since retired, has dealt the larger question and held that award of EA of foreign countries enforceable under Indian Arbitration and Conciliation Act. After the Competition Commission of India suspended its approval for the 2019 deal between Amazon and Future, the Future Group cited the CCI ruling in Delhi High Court to seek termination of arbitration and successfully secure the stay on the arbitration proceedings of the foreign government, which is Singapore International Arbitration Center. Delhi seated tribunal passed two awards. One held that Future Group was bound by the arbitration agreement, and second refused to lift the stay on the sale of asset deal between the Future and Reliance. Amazon filed an application before Supreme Court after Delhi High Court stayed the arbitration proceeding in the case. Now the case is in Supreme Court. Let's see what Supreme Court says.
Prashant, just go to the previous slide once. So, Future Retail Amazon is a high-profile case. There are many nuances to be discussed, and many questions of law will be answered through it. Part of it. One of the aspect is MBRT regulation, which is there. That is one of the thing which is there. Part of it. What exactly has turned around till now? That there was an investment which was being done by Amazon in FCPL. In FCPL, the investment which was being done, and FCPL held shares in FRL. So it's an indirectly Amazon will be having shares in FRL. Now the interesting part is that the business activity undertaken by both the entities, FCPL and FPRL. FCPL was cash and carry wholesale, but 100% FDI is allowed. FRL is in multi-brand retail, where even 1% FDI requires to a government approval route. Now the interesting question was that when the investment was done, CCI approval was taken and CCI had duly approved the investment. But when we know where the Future Group entered into a term sheet with Reliance, and finally it was agreed that Reliance Retail will acquire 30% for 24,000 crore part of it. At that point of time, Amazon, there was a restrictive clause that's a transfer restriction. A transfer restriction was there on Future Group that they can't sell to the competitor, and one of the competitor was Reliance Retail, which was being as a Reliance Group was one of the competitor at that point of time when the shareholders agreement was entered into it. So there was a clear demarcation on it, whether there is a breach of a regulation which is there, breach of the provision of shareholders agreement, part of it. Now the interesting question which came into play, there are, as I said, there are many questions of law will be answered. It's whether an emergency arbitrator award is enforceable or not. The answer is affirmative. Yes, it is. That is what Delhi High Court and Supreme Court has affirmed, that emergency arbitrator award is considered to be enforceable in Indian jurisdiction. That is point number one to be considered. The second point which is there, which requires a discussion point, which is that now once an approval is given, it was CCI had given approval on basis of the representations which were being made by both Amazon and Future, and on basis of the representation and submission which were being made to CCI, on basis of that which was approval which was being given in 2017, if I'm not wrong, in that is the period when approval was given. Now CCI has gone back and reversed his own approval. That is, the approval which they had given is been reversed, considering that indirectly there will be a share. Amazon will be holding shares in FRL, which is into MBRT, and in MBRT the investment has to be government approval route. and the investment which was done by Amazon in future was through an automatic route and not through a government route. So that was a question, and hence the CCI passed an order in December 2020, whereby it reversed its own judgment, its own approval part of it, that the whole investment which was being done, that was not a legal investment. So now what is future trying to highlight is that when the investment itself is questionable, then the terms of investment on which the investment was done, that is also questionable. And if that is also questionable along with it, then there is no question of breach of provision by future by giving it to Reliance. So the strategy which has been deployed by future group is that when CCI investment approval is already been taken off, so terms are not valid. If terms are not valid, then there is no breach. And if there is no breach, there is nothing there, then they can go ahead and sell it to Reliance. But there are again several petitions, several writ petitions, Delhi High Court, Supreme Court with arbitration tribunal, which are being there ongoing, which is that everything has been clubbed right now because there is already a scheme of arrangement is already been filed with NCLT, which no doubt a stay, there was a stay on the scheme of arrangement also, which was being passed. That stay has been taken off, part of it, that you can go ahead with the scheme of arrangement in the shareholders meeting to approve the scheme. But the question which still remain, which is there, if this is the case, when the investment itself, can CCI go back to their orders, which they have gone and they have asked that investment is not a valid investment, which is there now. In fact, Supreme Court has requested last week to settle both because both are the big names in its own way, which is there. So to settle the group, to do an out of court settlement terms. But there, if you realize, there was a last week, there was an error across explaining the whole case in detail. They have summarized, Amazon has summarized the whole case in detail, what things have gone and how things have spanned out for this particular thing. So this is an interesting space to watch for what will be the final conclusion by Supreme Court, whether it goes for an out of court settlement or whether there is a different route which is being taken, because this gives impression on the investment also, investment avenue also, because at the end of the day, Amazon is across the globe. It is not only in India which is there, and they are already having a well-established e-commerce segment, whereby they held 24% of a market share part of it. So this gives the flavor how the jurisdictions or how the judicial bodies are taking a view on a foreign investment which is there, and whether the honor of shareholders agreement or the terms of shareholders agreement will be honored or not. So this is an interesting space to watch for.
Yeah, and the same that this will be look at it from the impact and interpretation of arbitration award execution in India, how we are, because as per our own rules and provisions, on the ground of public policy, stop the execution and
Correct.
reject that. But here we have done it that through CCI route, where they have reversed it. If it's Supreme Court says that and it's a public policy, then it is something acceptable. And in international way, it also in the international eye also it is being watched upon, that how we are taking this arbitration award execution also. So I think from not only investment, that is FDI, that SHA agreement terms and the structuring, also CCI working and their validity of order and their rights to reverse their own order, and also the arbitration. So very complex thing, so many things are involved in this law.
Yes,
Contract.
Yes, ma'am. As rightly said, there will be many question of law which are never visited will be answered, and the validity of the EA order also. Anyways, the Delhi High Court has given Delhi High Court and Supreme Court has given that emergency award are constituted as a valid order, and as it is considered to be from enforceability point of view, it will be considered as a valid part of it. That the question on an EA order has been settled, but there are different nuances which will be definitely will need to be looked into it, how this particular case pan out, unless and until there is an out of court settlement, which
right
because Tata Docomo out of court settlement which was been done, so that does not give an answer to question. But if it is not, then this will go and end to the wire.
Yeah, thanks. Yeah, thanks, Prashant. I think you have concluded your presentation, right?
Yes, ma'am.
Hello.
Yeah.
Yeah, Jeevan here, madam. Good afternoon, madam, and good afternoon, panel.
Yeah.
Yeah,
Yes.
I have got one question. Can I take a liberty to ask one question on this only, Amazon
Yeah.
and future dispute?
Yes, sir. Yes, yes, very much.
Yeah. I have two questions. One is that you said there is a prohibition, there is a restriction on the part of the future that they cannot sell any assets to Reliance. So at the same time, there is a provision in our Indian Contract Act where, agreement in restraint of trade. You can't prohibit anybody to enter into trade relationship with any other party. So how do this provision gets assimilated with this restriction which Amazon has pushed on future? This is the question number one. And question number two, also there are some major turn of events is happening in last especially last 3-4 days, where Reliance has terminated the lease agreements of Big Bazaar Future and has taken the possession of all the retail outlets all over India. So will this act of Reliance be considered as a forceful, and will this take a different turn in the court?
Okay. So thank you, Jeevan, for the questions. We'll answer one by one both the questions which is there. To answer the first question, as you rightly pointed out, Section 26 of Indian Contract Act does not permit the restraint of trade which is there. But the language of Section 26 of Indian Contract Act says that reasonable restrictions is been allowed. Now, what is reasonable restrictions? That's a question. There are jurisprudence, there are precedent which we will come across of Supreme Court, Bombay High Court, Delhi High Court. The reasonable restrictions period imposed is either 2 years or 3 years period from the time of investment which has been done. That is what is the reasonability comes into play. Now, when what does the reasonable part of it? Now, when we say a competitor, so how does it gets covered under the shareholders agreement? Given it is that you define competitor, you identify competitor. It is a list of competitors to whom you can't transfer it, because if you transfer, consider if you transfer your business, then the purpose of investment gets fertile. There is no, because the reason investment is done is to get a return of an investment or part of it. But if you transfer your business to a competitor, it's a killer. There is no skin in the game left for the investor part of it. So to answer the question whether it is permissible or not, it is permissible. Restrictions is permissible, but it has to be reasonable in nature. Now, what is reasonable? The test of reasonableness is not yet determined part of it. There is no straight jacket formula for a reasonableness. But what is reasonableness is that it's a period has to be within a period of 2 to 3 years is considered to be a reasonable. And if it is within the reasonable period of time, definitely it is considered to be a valid and it's an exception. It's a carve out of Section 26 of our Indian Contract Act. That's a response to question number one. And for the second question which you raised, you're right that there are a lot of activity which has taken place of late from a point of view of future Reliance taking over from a retail. That's a master stroke, if you ask me, what has been done and the way it has been done. Because if you see, is a distress. Future Group is they are already an NPA in across the bank. If and the borrowing which has been done, there are 8 banks involved into it, and they have already classified Future Group account as a non-performing assets, and disclosing Future Group as a non-performing asset, which will have a big impact on a banking sector itself, which is there part of it. Now, when it's a distress sale, which I discussed earlier also, the distress, how FDI has helped in a distress in an IBC mode part of it. So before Future Group opens the door itself for IBC, this is a route which has been drawn. So what I understand is that there was a provision which was there in the term sheet which was being finalized between Reliance Retail and Future Group, that by this there was a long stop date. Beyond that, if it goes, then Reliance will have an option to take over the premises, the properties of Future, because the payment is already been done. If a payment is done, there has to be a consideration in return. Either they should get an assets or they should get a shares. Now, their investment is done, but their shares are being held in abeyance because of the litigation which is going on, and this will go on and on till the time there is a final answer to it. So what Reliance has played a master stroke in this is that they have taken an ownership of the store itself, by which it gives control to them. And once the control is there, even if Amazon wins the case or there is an order in favor of Amazon, I doubt Amazon will able to do much into it unless and until it's reverse the transaction which is done by Reliance.
Okay,
Thank you.
thank you.
Right, right.
Thank you very much. Thank you very
Well
much.
explained. Yes, thank you very much. Well explained. Thanks.
Thank you, Vishal. To add to your point, although in general, all agreements are in restrict of the trade is actually there, as you rightly said, the reasonable restriction, even after the termination of the agreement for the reasonable period, is permissible. That is the consistent views which has been taken by the Indian courts. Because in fact, I remember way back in 2006, I actually fought the case on this same conditions. Because the employee was working in an organization, he actually joined the competitor. Joining the competitor is okay, but the problem is using the confidential information of the employment where he was employed, which has been used in the competition where he has joined. That was the question. So in which case we actually used this particular contract only. He actually started saying, no, I am actually in the employment. Any restraint in the contract is not valid, etc. and other thing. This case was there. It was a popular case which was given by the Bangalore High Court judgment. If people are interested, you can actually see it is Shivram versus Posico India Limited in way back in 2006 or 2007. They have accepted and they said yes, a reasonable restriction, as you rightly say, 3 years is valid. So that will be valid actually here in this case.
Yeah.
So at this point.
Yeah, we'll take certain questions which are unanswered in chat box. And I think it says that if damage clause is included in shareholders agreement, then will it be looked upon as akin to assured return?
Okay. So damage is a separate clause under Indian Contract Act. It's a separate provision which is there. It's a contractual term which is being agreed part of it. So even if considered damage is not being agreed, that indemnity is a contractual term. Sorry, let me correct. Indemnity is a contractual term. Damage is a statutory right under Indian Contract Act. So giving a payment through a damage will not be considered as an assured return, and that is what the Tata Docomo case highlights, which is there, that the payment which was done, no doubt it was a payment which was being asked by Tata, which was being asked by Docomo from Tata for non-performance part of it, but the payment which was done under the head of damages. So under the damages head, it will be not be termed as an assured return.
Thanks. Thanks, Nirav, for raising question and contributing. Thanks. Okay, is assured return on investment available under Fema? Yeah, sorry. Hello, someone.
Yeah,
Okay.
sir, good afternoon.
Is assured return? Yeah, please.
Sir, I had 3 questions. Sir, is there any difference between FDI and foreign investment under NDI rules? That is my first question. Second is, how is the reporting process for a listed entity in terms of FC-GPR filing? Okay, that is one. Third, can you give some brief about NRO, NRE and FCNR accounts?
Okay, there is a distinguish between which is there. So non-debt regulation says about FDI and FPI investment which is there. So an FPI investment which has been considered, which is less than 10% in a listed company, will be considered as an FPI investment part of it. And FDI is any investment in an unlisted entity part of it, or any investment which is more than 10% in a listed entity will be under the category of FDI. And if it is less, it will be category of FPI. When if it is under a category of FPI, even the SEBI FPI regulations are become applicable and needs to be adhered along with Schedule 2 of non-debt regulation, where there is a classification given of FPI investment, that an FPI individual basis can hold not more than 10% of a paid up capital, a paid up equity capital on a fully diluted basis, and collectively not more than 24% on a paid up capital on a fully diluted basis. basis. That is to answer the question number 1 on what is a differentiate between FPI and FDI part of it. Second, whether in a listed company the reporting parameters are applicable. Yes, it is applicable. There is no exemption which is being given part of it. So it is applicable the way it is applicable for unlisted, the identical way it is applicable for the part of the FPI and FDI part of it. Question number 3 was on the NRE, NRO and FCRO account which is there. So Manoj, we will do a separate session on it because there are several requirements on it. There are certain requirements. What is permissible? What is not permissible? When what debits are permissible? What credits are permissible under it, which is there under NRE, NRO, and FCRO account. So definitely we will take up this when we do a separate session on it. But just to give you a glimpse of it, the investment are generally done through an NRE and NRO account, and there are certain limitations which are being imposed by RBI on each individual accounts also.
Yeah. Thanks, Vishal. And thanks for raising also the question and answer. Is assured return on investment available under Fema?
No, to answer it, the definition of equity capital itself says that assured return is not permissible.
Right.
So it is not permissible.
Okay. I think that's, there is a question. What does it mean to say that investment is on fully diluted basis? Any example to this?
Sure. A fully diluted basis is a defined term under the non-GAAP regulation itself. And fully diluted basis means if consider there are 100 shares and 50 options. So 50 options are also considered to be as a share. So it will be shown as on a cap table as a 150 part of it, because options are options. They are not yet been exercised. Consider ESOP as a part of it. It's not been exercised part. So when we say a cap table on fully diluted, we consider all the outstanding securities, including option, which is there. So that cap table will reflect 100 as a shares, 50 as an option. The total goes to 150. That is what is the meaning of fully diluted part of it. When you say the share capital term will be 100, but when you say a cap table on a fully diluted basis, it will be 150, which includes all the outstanding securities which are yet not converted into equity shares.
So basically future securities.
Correct. Future security, yes, options basically.
Yeah. Whether FC-GPR is required to be filed for FPI investment in listed company.
So there is a norm for it, which is required part of it. It's a SEBI requirement, which is
SEBI
there.
requirement, yeah. FPI is governed by SEBI.
Correct.
Yeah, I think this with this we are answered all the questions, and I think there is no more questions. So in that case, I think we can close the session. Thanks, Vishal, for your contribution, your time, we are seeing a lot of appreciation in the chat box continuously for you. So yeah, thanks, Sarita. She has mentioned specifically your elaborate discussion on the decided case and appreciated.
Thank you.
Thanks. Shailesh bhai, Shailesh bhai?
Yeah, I can hear you.
Yeah. Yeah, you would like to share anything on the topic and your experience on the thing, please?
Yeah, just 2-3 things I would like to share. Yes, Vishal has given a very elaborate presentation on this FDI regulation and how the FDI has evolved since 1992 till date. And the presentation also includes in which sector, what is the limit of investment is allowed under automatic route and under the approval route, also the prohibited sectors, and also the procedural requirement once the FDI is into the company. What are the requirements or what are the obligations of the company to report such investment to RBI through authorized dealer, and also filing various forms and returns on a periodic basis. That was nicely presented by Vishal and his team. The only point which I want to touch upon is that whenever there is a proposal of foreign direct investment in any company which is not gone under automatic route, the company has to be very careful in saying that whether when this investment is not through automatic route but under the approval route, and also the instrument which the company is planning to issue against this investment. So any approval is required from earlier it was FIPB, as Vishal has rightly mentioned. Now FIPB is not into picture, or it's dissolved now, and the Ministry of Investment Promotion is into the is looking into all this aspect. So one has to be very careful in making application to a right department in rightly manner with required forms and documents, so that your investment before the money is brought into your company, you have the investment. Because I have seen a couple of cases in past which I also handle personally, where the company has issued the instruments which were subject to FIPB approval at that point of time, and not taken the FIPB approval, and then they have to go for the compounding and have to pay the compounding fees and other things. So to avoid those things, because when investment is under automatic route, everybody is aware about the processes, and even the authorized dealers are also quite familiar with the entire process. But when it comes to a question of investment through approval route, many a time authorized dealers are also not aware about the procedural requirement, and in absence of that, sometimes company end up in making certain non-compliances, and then they have to pay a price in the form of a compounding of offense and paying the fees. So my humble request to all the participants is that pay special attention when the investment proposal is through a specific route, that is the approval route and not the automatic route. So that is what my feedback to the today's presentation, and it was indeed a very elaborative and very educative for those who are a quick learner or a beginner. And thank you very much for allowing me to express my views and thoughts on the FDI proposals or the FDI regulations. Thank you very much.
Thank you, Shailesh bhai. Thanks for your time. Thanks a lot.
I must say, excellent practical insight by Vishal, because he is thorough in his subject and he has actually thrown various aspects on the FDI. And really speaking, it also goes without saying that ultimately when it's come to the structuring, when you are complying, etc., and other things and all, we the professional have to take utmost care in looking into all these various aspects so that tomorrow disputes are avoided. And especially in the compliance matter also, we need to be very, very careful, because compliance in the non-compliance space nowadays, RBI is looking very seriously. Compounding is not the smaller amount. Compounding actually runs in multiple huge amount of the compounding fees which are levied by the RBI. In this perspective, I think we the company secretaries have got a larger thing to contribute and look into the various aspects. I think definitely this session has given the various insight to the participants. I am very sure they all got benefited. No doubt I also got enriched my knowledge in today's session. Thanks a lot. Thank you very much. Hats up to Vishal, and good presentation made by Prashant. Thank you very much. I appreciate both of you. And of course, I also thank Mr. Shailesh and other participants who interacted on this. Thanks a lot.
Thank you, Shailesh, sir, and thank you, Bala, sir, for it. And first of all, thank you, Dipti, ma'am, for providing me an opportunity to be a part of it and sharing my thoughts on it. And especially all participants getting engaged on Saturday, which is a bit of long weekend too, which is there, but still, everyone was being part of it. So thank you.
In spite of the long weekend, we had almost about 95% people participated today. Yeah.
Yes. So it was an interesting topic. And as we say that the role should not be limited to compliance. It should be a decision-making part where we contribute to the top management about what are the pros and cons.
Right.
Investment strategy from a holistic point of view, which comes into play. So that is whole objective. And thank you once again for inviting me. Thank you.
Thanks everyone. Thanks Vishal, and keep progressing and give proud to Mehta and Mehta. Thanks a lot. Thanks everyone.
Thank you.
Thank you.
Thanks Mr. Bala. Thanks Shailesh.
Bye.
Thanks everyone.
Have a
Bye-bye.
good weekend. Stay safe.
Yeah.
Take care.
Yeah.
Bye.